Good evening. This is Joe Heath again, and a reminder, I'm the General Counsel for the Onondaga Nation, and I'm speaking to you once again from northern Cortland County in New York State, which is really close to the center of the Onondaga Aboriginal Territory. And the purpose for this supplemental recording is to expand upon the problems that we discussed very briefly in the last session. The problem in the McGirt decision, the McGirt versus Oklahoma decision, and that problem being that its fundamental basis is the claimed right of the United States to plenary power over Indian nations, which really means that they say they can violate any treaty at will, terminate any nation at will. That's what plenary power really means, and I'd like to share more details of how damaging this power is. And it's the clearest way to really understand plenary power is termination, because the United States still claims the right to terminate any treaty, any nation, any provision of a treaty at will. And so that's what we're going to cover tonight. And we're going to use, again, a PowerPoint. And this is again, Oren Lyon's painting of the Tree of Peace. And we're going to be talking about plenary power and termination. And we'll remember that in 1823, the doctrine of Christian discovery was brought into U.S. Indian law by then Chief Judge John Marshall in the infamous case of Johnson versus McIntosh. And there he expounded that the right of Indian nations to complete sovereignty as independent nations was necessarily diminished by the mere discovery of the European nations. And those nations then claimed to themselves the right of ultimate dominion over the nations and their land. Ultimate dominion. And 130 years later, we also discussed very briefly the infamous case of Teton, in which this claim was made without any regard to historical accuracy. And we just have to remember that this is the ruling of the United States Supreme Court just a few decades ago within my lifetime, that every American schoolboy knows that the savage tribes, that's the language used by the Supreme Court, of this continent were deprived of their lands, and that even when they made treaties, it was not a sale, but the conqueror's will that deprived them of their land. And while we're discussing Teton, I would be remiss if I didn't share with you the finding that Steve Newcomb helped us with, which was the United States Department of Justice brief to the Supreme Court in the Teton case in 1954, the same year as Brown versus Board of Education. And here we have our Justice Department making these arguments that discovering nations claim to themselves by pure right of that discovery the complete and exclusive title to the Indian lands, subject only to the right of occupancy. And then they go on to talk about the great era of discovery. Well, it's not such a great era if you're on the receiving end of this colonialism and imperialism, but that's the title that's used to whitewash what happened in the 15th and 16th century. And so the Christian nations of Europe acquired jurisdictions over the newly acquired lands because of grants from the Pope, which granted the Christian monarchs the right to acquire territory in the possession. So here we have our Justice Department invoking the authority of the popes. And they also went on to quote Johnson versus McIntosh and saying that, well, yeah, so we deprived them of their sovereignty, but we amply compensated them in exchange for their sovereignty and right to govern themselves peacefully. we bestowed upon them Christianity and civilization in exchange for complete independence. And then the Justice Department went on to quote the Bible as the basis for this. They quote Genesis. And they say, and God blessed them, and God said unto them, be fruitful and multiply and spread across the earth and subdue the earth. That, I submit, is the basis for how we understand that the doctrine of Christian discovery and domination is at fault for what we're doing to Mother Earth these days, the pandemic of climate crisis. And last time we talked about the July 9th decision in McGirt versus Oklahoma, where Justice Gorsuch ruled that the Muskogee Reservation had not been terminated. And as I said before, that's a better ruling than the alternative. And that was followed a few weeks later on the 30th of July with the Seventh Circuit decision that applied McGirt to a situation where a village in Wisconsin claimed the right to have jurisdiction and authority over a festival that the United Nations put on. And the nation correctly argued, no, our reservation has not been terminated. And what the Seventh Circuit ruled is, therefore, most state and local jurisdiction and regulation cannot apply on a non-terminated reservation. Now, these are good rulings, much better than the alternative. So what's the problem, Joe? Well, this really is a debate in particularly McGirt between his majority opinion, where he's joined by the 4 liberal judges, and the dissenting opinion written, a pretty snarky one, written by Chief Justice. What they're really debating is, what are the rules for how we properly break an Indian treaty? Because that's what they're arguing about. And what Gorsuch rules is that, well, only Congress can break a treaty. Well, that is a fundamental problem, because this affirms and strongly reinforces the illegal claim of the United States government to have a unilateral right to break any treaty it chooses. Plenary power. And as we said in the last session, Gorsuch was very clever, because he never uses the term plenary power. And I think I agree with Steve that they don't use these terms anymore because they know that if people understood what they were really ruling, there would be a significant backlash to it. And so in order to understand how fundamental the rule of plenary power is to Gorsuch in his McGirt decision, we have to look at the cases that he cited. And he cites Lone Wolf versus Hitchcock, a 1903 case, and most Indian law cases from that period are very, very problematic, very, very racist. Lone Wolf is certainly no exception, because there the Supreme Court ruled that Indian nations only had the right of occupancy and it could only be interfered with by the sovereign, but it was presumed that the United States would govern such considerations of justice as would control a Christian people in their treatment of an ignorant and dependent race. This is the racist language used by the Supreme Court 120 years ago, upon which Gorsuch builds the McGirt decision. And in Lone Wolf, they went on to say that plenary power has always been exercised by Congress. Well, that's not true. It's a made-up power from the beginning, and that power has always been a political one, not subject to control by the judicial department of the government. So it's an absolute power with no right of review or checks and balances. Then they went on to write that when treaties were entered into between the United States and a tribe, it was never doubted that the power to abrogate, break the treaty in Congress was always present. Well, That's really not a legally justifiable position. Because, first of all, we have to look at the Constitution, which is supposed to be the fundamental document to particularly strict constructionists like Gorsuch. And the Constitution states very, very clearly in Article 6, Clause 2, that the Constitution and laws of the United States and all treaties made or which shall be made under the authority of the United States shall be the supreme law of the land. Now, that doesn't say that then the United States can go out and break them at will. So let's take a closer look at what plenary power actually means. Because most of us do not use that term, plenary, in our day-to-day discussions. And I submit it's another Orwellian-type word that's meant to hide the true negativity of what it's claiming. Because then, again, we need to remember that this is a claimed right of the United States to have complete power in every aspect over Indian nations, or absolute power. This is what the dictionary tells us, or unqualified control. So if the Supreme Court were to write in these clear terms, we would have a better understanding of the dangers of plenary power. Absolute power. That's what the Supreme Court keeps saying. Because absolute power equals that ultimate dominion that Marshall wrote about in Johnson versus McIntosh. This theory, this claimed right by the United States, is so fundamentally bogus and has no constitutional basis that even Clarence Thomas has repeatedly questioned the claim of plenary power. As recently as 2016, in one of his concurring opinions, Thomas wrote this: Congress's purported plenary power over Indian tribes rests on even shakier foundation. No enumerated power, not Congress's power to regulate commerce with Indian tribes, not the Senate's role in approving treaties, not anything else gives such sweeping authority. He's correctly saying there is no basis in the Constitution for this claim of complete authority. And this is not his only opinion where he questions plenary power. There's at least 3 or 4 of them within the last 10 years. They don't ever change the outcome of the cases in which he files these concurring opinions. But he has consistently been critical of this claimed power. And we need to understand why the bogus claim of plenary power has made U.S. Indian law such a complicated and contradictory set of rules, because they make these rules up as they go along. And Vine DeLorean reminded us of that in 1972, when he wrote that when the U.S. is creating federal Indian law, it skips along, spinning off inconsistencies like a new sun exploding comets as it tips its way out of the dawn of creation. In other words, the reason that we don't find logical, clear rules of construction as it applies to Indian nations is because it's all artificially based upon illegal claimed authority of plenary power. And what does plenary power mean day to day to Indian nations? It means that the United States claims the right to terminate any nation, any treaty at will. And not only claims the right, but our recent history shows us that it's eager to exercise that right. And that's a period of termination from 1943 to 1961. All of this is within my lifetime. And that's the period of termination. And that was the stated goal and policy of the United States government. We started in 1952 with a House resolution that was designed to promote the earliest practical termination of all federal supervision and control over Indians. The next year, 1953, a concurrent resolution in the House declared that it was the policy of Congress as rapidly as possible to make Indians subject to the same laws, entitled to the same privileges and responsibilities as other citizens, to end their status as wards, grant them the rights and prerogatives pertaining to American citizens. Then a couple years later, in 1956, we had the Indian Relocation Act. Relocation, another Orwellian word to cloak the real meaning of removal, of ethnic cleansing. And so this Congress passed an act in 1956 to relocate or remove Indians from their homelands. And it was designed to encourage Indians to leave their reservations and their traditional homelands and to move into cities and to assimilate into the general population in urban areas. This was the open policy of the United States government in the 1950s. And so from 1953 to 1964, 109 nations were terminated. Over 2.5 million acres of trust land were removed from their protected status, and 12,000 indigenous people lost their tribal affiliation. So we have United States law resting upon this claim power to terminate any treaty or reservation at will. And we have clear examples of how the United States government is very eager to do that, to carry out the final assimilation and termination of all Indian nations on Turtle Island. So what should we do as Indian law practitioners? Should we jump on this bandwagon that's willing to crow about how the landmark case McGirt is? No. We should follow the example of the Yankton Sioux Nation in its 2016 complaint against the Army Corps of Engineers to stop the construction of the Dakota Access Pipeline. Because the Yankton Sioux, in their complaint, their first cause of action was a direct challenge to the claim of plenary power. And they start by properly going back to the fact that they have an 1851 Fort Laramie Treaty. And because they're a signatory to that, and because they don't consent to the pipeline, which would transfer its treaty territory, the construction and operation of that pipeline would be a trespass. Now we know from having been at Standing Rock and doing some treaty research there that subsequently the United States grabbed millions of acres of land that was protected in the original 1851 treaty in 1868. And it's through that section of illegally taken land that the Dakota Access Pipeline traveled. And the Yankton Sioux challenged that because that was within the boundaries of their treaty territory, which has not been diminished by Congress. And what they said was that because our treaty boundaries were illegally diminished, because Congress exercised its plenary power, such alleged power, in fact, violates Article 6 of the Constitution, which declares that treaties are the supreme law of the land. And so I submit that every time we are confronted with an illegal exercise of plenary power for our nations, that we must challenge that presumed authority head on. Failure to do so will leave Indian nations without any significant protection within our courts, always subject to the plenary power claimed that could terminate a reservation at will without judicial review. And to just briefly bring this conflict home to Haudenosaunee territory, let us compare what the Supreme Court just said last month in McGirt, that a reservation is intact until terminated, with what the settlers around the Cayuga Nation, just to the west of here, still claim today. This is a sign that you'll see dozens of if you drive around the northern end, particularly the northern end of Cayuga Lake. Because the Canandaigua Treaty created a 64,000 acre reservation for the Cayuga Nation. It sits like an inverted U at the northern end of Cayuga Lake. That reservation has not been terminated. And yet we have local citizen groups, the Upstate Citizens for Equality for them, certainly not for the Cayuga Nation, saying there's no reservation here and there's no sovereign nation here. Well, that's not true. There is a reservation. The Supreme Court says so. And yet, this is the kind of reactionary resistance that the Cayugas have been encountering for decades as they try to reestablish a base within their homeland. So that's what I wanted to talk about, that we must be very, very suspicious of the claim of plenary power. It's an illegal claim. It has no constitutional basis. If Clarence Thomas can see that, we all should. And that ultimately what it means is termination. Those are not principles of Indian law that we can accept, and we must continue to work against. Thank you very much for listening.